Class action lawsuits are often used to address situations involving defendants who unfairly receive small amounts of money from many individuals. For those individuals, there's strength in numbers, but one person discovers the challenges of class action litigation expenses in Eisen v. Carlisle and Jacquelin. Morton Eisen traded in odds on the New York Stock Exchange. Trading in odds referred to buying and selling stocks in groups smaller than 100 shares. Two brokers, Carlisle and Jacquelin and DeCoppet and Doremus, handled all but 1% of odds trading. With odds trades, brokers tacked on a surcharge of as much as 25 cents a share. Eisen's surcharges totaled about $70. Eisen filed suit against the brokers, arguing the surcharges violated the Sherman Act and Securities Exchange Act. Because Eisen's claim was worth so little, practically it didn't make sense for him to proceed with the lawsuit unless he was able to make it a class action suit. The district court held that Eisen couldn't bring a class action claim. Because this effectively ended his case, the Second Circuit, in a case referred to as Eisen 1, decided Eisen could appeal right away. Then, in Eisen 2, the Second Circuit examined Federal Rule of Civil Procedure 23, which addressed class action suits. Under C2, Eisen needed to give notice to identifiable class members, but he argued mailing notices would be too expensive. The Second Circuit remanded and ordered a hearing about notice and managing a class action. On remand, the court struggled to identify the specific class, so it used a fluid class that didn't precisely cover the injured traders. The court determined that the class could have as many as 6 million members. About 2 million members were identifiable by name and address. With some effort, more could be identified. Mailing notices would cost over $200,000, or substituting publishing a notice for many would cost over $20,000. The court allowed the cheaper publication approach and held that, because Eisen would probably win at trial, the brokers needed to pay for 90% of the notice expenses. The brokers appealed. In Eisen 3, the Second Circuit reversed the district court, dismissing the class action because it ran afoul of Rule 23. The Supreme Court granted cert.